Thank you, Kelly. This is Kathy Martin. I want to welcome everybody. This session focuses on how to use bankruptcy, specifically Chapter 13, to maintain housing. So we're going to talk about homeowners and tenants and how they can benefit from bankruptcy. Alfonso is advancing the slides. So there are three of us. I'm from Neighborhood Legal Services. We have Alfonso Madrid from CLS in Philadelphia, Eileen Yacknin, one of my coworkers at Neighborhood Legal Services in Pittsburgh. Between us, we've done a lot of bankruptcy cases through the years, and we covered the Eastern and Western districts. I tried to find someone from the Middle District, but they did not volunteer any information, but put information in the chat box if something we say is different for you in the Middle District. We're going to try to, if we have time, we're going to talk about the homeowner issues first. If we have time at the end of that, before Eileen starts talking about landlord tenant, we will try and address some questions in the chat box. Otherwise, we may just have to get back to you after the session's over. So this session doesn't talk about any really basic bankruptcy ideas. It's just like focusing on homeowner and tenant issues. But there are two introductory sessions on bankruptcy, boot camp part 1 and part 2. Part 1 is scheduled for September 22nd. Part 2 is scheduled for October 21st. That's not on the official schedule yet, but it will happen. So let's get started with this part.
And it's worth noting that, you know, because we only have 90 minutes, I mean, bankruptcy can involve a lot of procedures, a lot of forms. We are going to touch on things generally, so feel free to ask questions as they come up if you don't necessarily see it on a slide or something.
Next. So I've always liked this cartoon. I think that bankruptcy is a little bit different from most of what we do at legal services. Usually we're defending things. A client gets sued or they're denied benefits, and then we're reacting to that. Bankruptcy can be proactive. It can be a very good, lead to some good results for your clients, most of which are not intuitive. And that's the purpose of this session, to point out these other things. So just think of yourself as a creative person, even though you're a lawyer, and try and practice Zen in the art of bankruptcy.
I mean, people might think that it's a very dry subject. I mean, bankruptcy is very code-driven and rule-driven, but there is a sort of art to it. And as you do more and more bankruptcy cases, you really become familiar with the idiosyncrasies of your own district and the trustees. And you know, what I love about bankruptcy is it's a very economic forum to help your clients resolve their debts, but also bring affirmative claims. And sometimes it's a faster forum than the state courts usually.
And I'll add a couple of comments too before you get going then. Bankruptcy is an extraordinarily powerful tool to stop something bad from happening to your client when there are no other options or when those options have failed. And even though it's new language and new types of doing things than what we're often doing in our practices, if you can overcome the terror of entering into the world of bankruptcy, use a little Zen there, then this can really help tenants, help so many people, our clients, and the reason is because of this automatic stay, which is automatic. And the other thing about this, which I think about bankruptcy, which is so different than normally in our common pleas trial practice, is that the judges in bankruptcy court are used to people who don't pay their bills, and that's not something that's such a terrible sin. So when you want to try to defend a foreclosure action, and all the judge can say in state court is, well, did your client pay the mortgage or not? The same for landlords. So if and you know, judges there. So that's why bankruptcy, I hope we can urge you to consider using bankruptcy if it's appropriate and if it can help, and it can help.
Yeah, I think it's an underutilized tool for low-income people. It strikes people as labor-intensive, and people may shy away from it. We here are here to proselytize and urge you to consider it. Next slide. So I want to talk about how to use Chapter 13 to save your client's house. And outside of bankruptcy, you will have noticed that if you're trying to make a deal for your client, it doesn't happen until the lender agrees to it. The beauty of bankruptcy, one of the basic benefits is that the debtor, if you're filing Chapter 13, the debtor can resume monthly payments and pay the arrears in installments, even if the lender doesn't agree to it. So that's a big difference. Even if you can't do anything fancy, even if you can't do these things we're going to tell you are available in Chapter 13, at least you can do this, and that's better than being out in the real world outside of bankruptcy. There are objections a lender could raise, but they're not that common. Most of the time, if all you're trying to do is file Chapter 13 and pay the arrears and installments, you're going to be able to do that.
And it can also even help you if your client has a hiccup after the case is filed, as sometimes happens. Sometimes it's easier to fix falling behind again after the bankruptcy when you're in a bankruptcy court.
Yes, good point. So the Western districts where I practice and the Middle districts, according to their court website, both offer sort of a mortgage modification program, an attempt to modify the loan within the bankruptcy. And I don't use it that much because I have not found it to be that helpful. I try and exhaust that possibility before filing bankruptcy. Alfonso told me that there's a way of just indicating on the plan in the Eastern District, so I'm not familiar with that. How would that work?
Yeah, we don't have a formal modification mediation program in the bankruptcy court, I think primarily because in Philadelphia, we have an excellent diversion program in the Court of Common area have gone through that. So our plan, I think part of a way to sort of balance that out is you can check off an option in our plan that says we're going to seek a loan modification. And it's basically, some form language. You say how long you're going to allow for it. And if the loan modification isn't granted by such and such date, then creditor gets relief from stay or debtor will amend their plan otherwise. We always get objections from the creditors because the mortgage is going to say, oh, that's speculative. But here's the thing, we don't get to confirmation of a plan until about 6 months into the case anyway. So we're usually going to have the time to go through that modification process if the client hasn't done so before bankruptcy.
I will just very briefly point out that Chapter 13s typically cannot last longer than 60 months. Right now, we're in a temporary period of 1 year that started on March 27th, 2020, that under the CARES Act, a Chapter 13 case that has already been confirmed as of that date, you can request an extension of the plan term beyond the 60 months to a maximum of 84 months. But that's only going to be an option until next March 26th, I guess.
It's worth noting, though, sometimes, although the code doesn't allow you to propose a plan that lasts longer than 60 months, if you get to the end of a 60-month plan and you have a client who's fallen behind, there is some discretion to allow a few extra months. That's what makes bankruptcy, I think, such kind of a unique vehicle. A lot of it depends on who's objecting. And the trustees will sometimes, you to get to the 60th month, but your client fell behind on payments, can get a few extra months. I mean, it's not going to be an excessive amount, but you can kind of actually have a 65, 66-month plan, technically. Right.
Everyone just sort of ignores it.
Yeah.
The fact that it's taking longer. Okay, great. So in the Chapter 13, usually the mortgage lender will file a proof of claim. And then, as Alfonso pointed out before, it's a really good place to litigate those issues. I have found state court to be an unsatisfactory place to win a fight on how much money my client owes. Bankruptcy is a whole lot nicer place to be arguing about those things. So in Chapter 13, the general rule is that a secured claim can be modified. That's one reason people file Chapter 13. That's why businesses like Chapter 13, that they can change the terms of their contracts. Debtors, individual debtors get that right too. So that's the general rule. There's an exception to that general rule, which says that you usually cannot modify a security interest in the principal residence of the debtor. But if that's all we had to say, we wouldn't need this session, because then there are exceptions to that
exception
to the general rule. And the exception is that sometimes you can modify the mortgage, and we will be telling you about those times.
Since we're primarily talking about mortgages, I mean, you can do a number of things in bankruptcy, deal with car loans and stuff, but we're talking about saving home. Usually we're talking about mortgage. It's worth just doing some basic terminology. It's worth just noting the difference between the mortgage and the loan. You know, the mortgage is the security interest. It ties the loan to the property. The loan is evidenced by the note between that the borrower signs that gives the person personal liability. So when we're talking about modifying the mortgage, we're really modifying what the client's paying. We're modifying the loan. Well, we may be modifying the mortgage in the sense that we're reducing the security amount to the value of the property, as we discuss later. But it's a fine difference worth keeping in mind. So after you file your bankruptcy, all your bankruptcy paperwork, which you'll probably see in the basic boot camps, you know, your schedules and statements, what you're doing is you're waiting for your meeting of creditors to be scheduled with your Chapter 13 trustee and noting the deadlines in your case. So you want to put down your meeting of creditors. You don't want to miss that. Here in the Eastern District, we're doing those telephonically. We may move to Zoom at some point. The deadlines are based on the filing date. So most claims have to be filed by creditors within 70 days of the date of the petition date. Governmental entities have 180 days. So if you're expecting claims from the city or county, IRS, those may not come in until 6 months in. There might be some tricky things. Pennsylvania Housing Finance Agency. Are they a government entity? Catherine, what do you think?
They usually file their claims fast.
They do.
Experience. So I guess they don't want to have to argue about that.
Yeah, I mean, it used to be they took a lot longer. Now I find they're getting them usually within the 7 days for the first mortgages.
Yep.
HEMAP loans, I've noticed, get filed very late. So if you have a second mortgage as a result of a HEMAP loan, I think because those are done in-house, perhaps, those often don't get filed till, I noticed, till almost the 180-day mark. I have filed proofs of claim on behalf of a PHFA for heat map if I wanted to get to confirmation quickly. Mm-hmm. So it's important to keep those deadlines. Most of us use something like Legal Server or something for manage our caseloads. I'll put deadlines in that, and I'll also put them in my Outlook calendar. If you use bankruptcy software like Best Case, that has calendaring options as well, so you can do the trifecta and doing that and make sure you don't miss anything. So typically whenever anything is filed in a bankruptcy case, you're going to get an electronic notice, an email with a link to that. So that includes any pleadings as well as every proof of claim. So typically as claims come in, I'm not paying a whole lot of attention to unsecured claims. We'll talk about that in a second because most of the time they're not going to get paid. I'll take a quick look, maybe file that away. I'm looking for my secured claims like the mortgage, maybe a second mortgage or a car loan, or priority debts. Now, priority claims are claims that are given priority under the bankruptcy code. For most of our clients, that really means income taxes or child support. For child support, most of my clients are usually having it taken out of their wages anyway, and the state's happy to continue doing that, and the code allows that. So usually it's income taxes. It's worth noting, a requirement of Chapter 13 is that you have filed all your tax returns for the 4 years before your case. I don't ask for all 4 years of tax returns for my clients. I usually ask for the last 2 for, so I can get information for the forms, but I do press them. Have you sure you filed? It's not uncommon for many people to not file their Pennsylvania returns because they say, sometimes even preparers will tell them, oh, you don't owe anything, you don't have to file it, but you do. And you may be having to scramble to get some get those returns filed. And usually you're going to have some time after the bankruptcy to do that. So during the first 70 days, we're looking at claims and seeing what we can object to. Okay. Now, when do you need, remember I said I don't pay a whole lot of attention to unsecured claims. Now, unsecured claims are things like credit card debt, medical bills, student loans. Usually those claims don't get paid in a plan because our clients can't afford it. They're usually enough just, you know, if we're looking at their income, they don't meet that second prong of having income to pay the basic living expenses, pay their secured, and have extra money. They do, however, unfortunately, sometimes have houses with equity. And you know, the house is their only basic asset. So we have to do what's called sort of a fictional liquidation analysis. And most bankruptcy software has a thing that you look at the value of the house, what other liens are on there, and what exemption your client can claim in their real estate. And depending on how the number will work out, there may be a certain amount of money that has to get paid to unsecured creditors. But that, luckily for most of our clients, is typically not the case. All right, in addition to the claims that get paid in the bankruptcy, when you're doing what we call a traditional cure plan, in other words, you know, as Kathy mentioned earlier, sometimes we can't do anything fancy. We're just paying off the pre-bankruptcy payment arrears through the plan, and while the client continues to pay their mortgage going forward. But things happen with mortgages post-bankruptcy. So there can be fees and costs that were incurred after the bankruptcy filed. And so we now have Rule 3002.1. And the rule was acted when it was enacted, I think 2017, or maybe it was a little bit earlier. Part of the problem was that people would get through a Chapter 13 plan, having made all their payments, and they thought they were current. And then maybe several months after the case, the mortgage company, oh no, we did all these inspections and we had some escrow advances that you didn't pay, so you still owe us this much money. That's what this rule is designed to do. So it only applies in cure plans where you're curing arrears and making post-petition contractual payments. And the mortgage company has to file a notice within 180 days of the fee being incurred after the case was filed. If they fail to do that within 180 days, we can ask the court to preclude any evidence and potentially get attorney fees. I've never gotten attorney fees on that, but the incurred after is underlined because it is important to take a look at. I have seen some mortgage companies try to file as post-petition costs things that were actually incurred pre-petition, but which they didn't get invoiced for, either like by the sheriffs or something, until afterwards, and they've tried to stick it in as a post-petition fee. And I'm like, well, no, you actually incurred that pre-petition. It should have been in your proof of claim. You didn't include it. The plan is confirmed. You're stuck. Now, the process for that is, one thing with proofs of claim, when the mortgage company files a claim for their pre-petition amount, that's given a prima facie effect. The burden is on us to show that the claim is incorrect or overstated. With post-petition fees and costs, burden shift, there is no prima facie. So if they're filing for a notice saying that there are some post-bankruptcy fees, they're not entitled to any presumption, and you can challenge it. Now, the rule says that if you bring that challenge within 1 year, the court must hold a hearing and determine an objection. Some people refer to that as a deadline, because I think the way the rule is written, you could still bring it in after a year, although theoretically a court might have some discretion to not hear that motion because it's after the 1 year. I've never chanced it. Those are things where I always calendar those in, but I think you probably could. And I think there's an argument to be made that you could still do that. One thing you should also be aware of is this is just a bankruptcy rule. This provides one process to object to a post-petition fee and cost. If you were outside of bankruptcy and your mortgage company charged your client some outrageous fees, we'd all be thinking, UDAP violations or fair debt collection violations, you still have those. Bankruptcy is not, just because a person's in a bankruptcy case does not preclude them from raising those separately. This is I got muted there for a second. Did everybody, that was very strange. How much of me did you lose, people?
It was a vital piece of information.
That's very weird. I just got this pop-up that says you've been muted. All right.
Sorry about that, Alfonso. I was letting someone in from the waiting room, and suddenly my mouse jumped. Sorry.
I was like, I know I'm a little chatty, but sometimes. So anyway, so this gives you one method to challenge these fields. So typically what I see for, I
just want to point out, I mean, you could file a notice of error outside of the bankruptcy.
Exactly.
Yeah, don't give up.
Yeah, I mean, this is one avenue of redress that the bankruptcy rules expressly give you. You still have all your other avenues of redress. But typically for someone who's doing a cure plan in a bankruptcy, the stuff that I see are bankruptcy, or what they call bankruptcy fees. And sometimes you'll see that on the notice. It'll just say bankruptcy fees, or maybe there's the notation. Typically they're charging you for having an attorney review the plan, maybe having filed an objection to confirmation of your plan, or preparing the proof of claim. In my point, these are all objectionable because these could be done in-house. And in fact, where I used to see a lot of this more, I'm seeing a little bit less, is PHFA. And because I know PHFA prepares their proofs of claim in-house, and they simply give them to counsel to review, which is a very expensive proofreading, and charging our clients $800. Every time I've raised an objection for post-petition fees and costs, typically they're withdrawn. And I think it's maybe more of a cost of litigation type of thing, so it's worth raising those. Less common things I see might be bounce check fees for mortgage payments that the clients may have made, or if you have a mortgage that's not an escrowed mortgage, maybe a HELOC, and the mortgage company advances taxes and insurance, they might file in for that as well. But I tend not to see that. Late fees in bankruptcy. Now, typically for most mortgages, if you're paying after 15 days from the first, there's a late fee. I think most lenders waive these simply because this rule requires them to file these notices. So I rarely see late fees, on a notice of post-petition fees and costs.
One thing my experience is that we do surprisingly well with any of these objections, and as Alfonso said, it may just be sort of cost of litigation analysis. One lender's attorney said that his client had told him, don't fight anything, most Chapter 13s fail, and then we get to plow all those costs back on. Don't be shy, make these claims. They have to be legitimate. You have to have an argument to make, but you may do better than you'd think.
Yeah, here is actually a practice point. Because I have a year under the rule to file these, I won't usually bring them right away. I typically will wait at least 6 months into it because statistically there is a possibility my client may fail, and I don't want to put the work into it. I mean, the reason I think for allowing a year is also most post-petition fees and costs are going to be incurred in that first year. So it allows you to see if any other things get filed, and you can bring your objection all at once on several of them. That's sort of what was thought when they put that in there. But I think, so what the first thing I do when I see a notice is I calendar it for a year out. It's maybe a tickler like a month before to take a look at, and save myself a little bit of work there. But let's talk about the proof of claim, because that's typically what you're really going to object to in a mortgage proof of claim. So fortunately, we now have this Form 410A, which gives you a summary of what the claim is, and then a payment history for the date of default. And sometimes it's even the whole payment history, the whole loan history. PHFA, again, is one I'll see one going like 20 pages of those, which can sometimes be helpful if you scour through them. But typically what I'm looking for are excessive attorney fees. I kind of have my own rule of thumb, like between $2,500, $3,000. If it's going over that, then I'm looking a little bit more closely at that. Excessive conciliation or mediation fees. So typically, I think most lenders here in Philadelphia are charging like $200 to $300 every time you go to one of these mediation sessions in the Common Pleas diversion program. And I think even the HUD regulations all have a certain base amount that they allow. But I will sometimes note that they'll charge like $700 for the first one and then $300 for the ones after. And I'm like, well, why is the first one so expensive? Because in our diversion program, the first hearing, nothing happens. It's like if you show up, you automatically get a second a second hearing scheduled. So nothing of substance happens in those. So I never understood that. Sometimes I've had clients that were in our diversion program for like well over a year, sometimes 2 years, if servicers changed. And there could be a ton of fees that I think would be objectionable and maybe even a basis for an adversary action. Late fees after the loan has been accelerated. You know, once you've gone into foreclosure, they shouldn't be charging your client late fees for missing the monthly mortgage payment because they have accelerated the mortgage and there are technically no payments due. I have, you know, typically I see those maybe 50% of the time. I think what I'm seeing more and more of now is I think a lot of them have realized that, and I'll see them zeroed out at the end, or, you know, countered with the credit. Sheriff fees. It's not uncommon for the lender to, or the servicer to give the mortgage attorneys everything, you know, including the money for the sheriff's deposit. But if we file our bankruptcy before judgment's entered, that money hasn't been spent. It's likely sitting in the attorney's IOLTA, and it shouldn't be billed to the client. Inspection fees are another one. The drive-by inspection fees, anywhere between $15, $20 every month going by. I usually will object to those. Now, you can file a formal proof of claim objection to the proof of claim. I find that with certain lenders and a certain counsel who's representing that, I can do a lot of this informally. So there might be like a short list of people I know I can reach out to the attorney and say, hey, you've got this, this, and this. Is your client willing to strike these out rather than me objecting? And we can do a stipulation. So that's kind of one of the, I think you get a little bit more of that play in bankruptcy than, you know, if you were litigating this. Okay, another thing you can object to is if you're doing a payoff plan. We're going to discuss that a little bit more. Sometimes it's worthwhile to pay off your mortgage in full in the bankruptcy. And sometimes you can save a lot of money if that mortgage has already been reduced to a judgment in foreclosure, because there may be some escrow advances and fees that were accrued after that judgment that don't have to be paid under what's called a merger doctrine, which says that when there's a judgment in foreclosure, the contract merges into the judgment and doesn't provide a basis for these fees, unless there's a clause, again, there's an exception to almost every rule, that says this will survive judgment. So sometimes I can shave off a fair amount if the mortgage is an amount that's that's low enough that the client can pay it off over 5 years. But you will often see that even when you propose a plan that's going to pay them in full, the mortgage company doesn't file a claim that matches your plan. They file a claim that like you're going to cure it, and they may have all these fees and costs that are precluded. So what I do with my payout plans is I look at the judgment date, and I'll write a red line across the payment history at that date and look at those fees. One area that I have found sometimes helpful, forced place insurance. I have sometimes had some Hail Mary cases where my clients really couldn't afford an arrears payment plan, or I can think of one in a reverse mortgage case. There was a lot of forced place insurance, but I Googled and saw that this mortgage company and these insurers were the subject of a class action. I looked into that and I brought a class action. I brought my own complaint based on that, which basically was a kickback scheme between the mortgage company and the insurance companies, and was able to settle that and close out that bankruptcy early. So sometimes Googling is a good way to find out some ideas that you might get if you really need to bring down your claim. Now, claim objections can be brought just by filing an objection, or you can do them in conjunction with an adversary, or both. A lot of it's a matter of preference. I know some people like to just file their claim objections to kick off some things, and then they may have affirmative causes of action, and they do that by bringing an adversary proceeding. Depending on my timeline, I usually just will throw my claim objections into like count 1 of the adversary of my complaint. Count 1 is an objection to your proof of claim. Count 2, violations of Act 61 or UDAP or anything that I may have. The other thing that can happen post-bankruptcy with mortgages, if it's an escrowed mortgage especially, is the mortgage payment changes. Just like when you're out of bankruptcy, about once a year, your loan gets reevaluated based on taxes and insurance, and your payment may adjust because your escrow account has to be adjusted. That can happen in bankruptcy. Now, Federal Rule 3002.1 covers that. Kathy, does your local rule give you more requirements than the federal rule?
Sorry, I don't think so.
Okay. So basically, when they file a mortgage payment change, they are attaching the escrow analysis. So here's the one thing that I always look for in these is this is supposed to happen once a year. Now, my mortgage company, for example, does my escrow analysis every April. But what if I filed a bankruptcy because I'd fallen behind on my mortgage? I filed a bankruptcy in August. Well, as part of the proof of claim, the mortgage company has to do an escrow analysis. And you will see in your proofs of claim, usually there is a portion that says projected escrow shortage, because when you file your bankruptcy, you are giving the illusion that you have been paying. You are now contractually current. So there should be money in an escrow account as though you had been paying, and that's factored into the proof of claim. So there's absolutely no reason 3 months later for you to get a notice of mortgage payment change. Typically, your next escrow analysis should happen after the bankruptcy. Kathy, how many times do you see that happen before that?
Every case.
Yeah. And on that basis alone, I'll object. I'll be like, listen, this can't be right. You're assuming that, that this needs to be adjusted, even though you just adjusted it when we filed the case. So things I look at when you look at the escrow analysis is it'll show you, here's your current payment, here's your new payment. Well, that current payment should be the mortgage payment amount that's reflected on the proof of claim. If it's not, you know that what they're doing is they're doing an escrow analysis as though your client's not in bankruptcy, and it's not accounting for any of the things that they should be accounting for. And so on that basis alone, you should be able to raise an objection. I don't have to explain exactly what's wrong, because with a mortgage payment change, again, there's no presumption in their favor. Once I raise the challenge, burden is on them to explain why the mortgage payment needs to change. So typically, if it's, I will usually get them to either withdraw this, and sometimes I've just had them not show up. I now have 2 orders that have stricken the mortgage payment change and I put in language in my proposed order that has now abrogated the rules, so they are not allowed to change the mortgage payment without filing a motion. I know they're not going to pay attention to that order. And so I'm queuing this up for the contempt order on a motion I'm going to be bringing probably about 6 months. But that's like a little tool that you can have, and that might be enough to maybe get this client a loan modification and end that bankruptcy early. So these can actually be little things that can help you in a bankruptcy case. The other thing the other reason a mortgage payment might change is if it's an adjustable rate mortgage. Fortunately, I don't see a whole lot of those for first mortgages anymore. With the 2008 crisis and HAMP, a lot of those have been, been turned into fixed rate. I do see them with HELOCs. And I know that the rule recently changed to make it a little less burdensome for the frequently changing one. I'm not exactly sure what they are because I haven't had to deal with it. But for those ones, you may see mortgage payment change more because the benchmark, the LIBOR, the Wall Street Journal benchmark is changing. And I will usually just verify that. Usually it's not a big mortgage payment change for those ones. Okay.
So what we've talked about so far is what do you do with sort of your standard case where you're just looking at how much the lender says is owed and you might quibble with it, but you're not doing anything, not really modifying that claim. So now we're going to talk about modifying the claim. And so as I said before, it means you're changing the terms of the contract. Businesses do this all the time. And this is different. Unfortunately, they use the same word. They call it modifying, but it is not the same as modifying a loan outside of bankruptcy. So when we're talking about it inside of bankruptcy, it's sort of a term of art, and we'll try and walk you through some of those things. It's much easier to modify other things. Car loans are sort of low-hanging fruit for reducing your client's expenses. You can always modify the interest rate on a car loan, but it's more complicated and more difficult to do it on a mortgage. So next slide. We're going to talk about when you can modify a mortgage, and there are basically 3 ways, 3 times when you could do it. A mortgage loan that matures before the end of your Chapter 13 plan. If the mortgage has language in it that takes a security interest beyond just the real property, or if there is a completely unsecured junior mortgage. So we're going to talk about those, but those are the three things. So there's a difference between what you can do with a first mortgage and what you could do with a junior mortgage. So we're going to talk about first mortgages first because they're first. So there are two things to look at if you're dealing with a first mortgage. One is read the mortgage. They are not interesting reading, but they could be profitable for your client. The mortgage should be attached to the proof of claim if it's been filed already. And if not, it may be attached to the foreclosure complaint in state court. In Allegheny County, we are fortunate that the public records, we can access mortgages online easily. I know that's not true in all counties, but you do want to get your hands on that mortgage and read it. So the one thing you're looking for is there language in it where they're taking a security interest in something beyond just the principal residence. This used to be, for those of us who've been around a long time, fertile ground for challenging mortgages. So fertile that they amended the bankruptcy code to change the definition of what a household is, so that this is no longer very fruitful. But if there's an old mortgage especially, it's worth reading, looking at the language to see if there's some sort of boilerplate language in there where they're taking, they got greedy and they took a security interest in other things. In
today's modern world, I think we're more likely to see these maybe in business loans, like maybe your client took out a second mortgage to his business. So those might have a security interest in some business property as well as the first mortgage. That's the one I think I'm likely to see most common anymore.
Okay.
Sorry, if I could just interrupt quickly. I was trying to find a place to do it between slides, but I'm sorry. This is Kelly. I'm launching the first of the 2 CLE poll question boxes. Please respond to it now, and I will leave it up for 2 minutes. And presenters, feel free to continue. You don't need to respond to the poll. You can just click off of it.
Okay. I'm going to try and speed up here. I see we are taking a bunch of time. Eileen, sorry. We'll be as fast as we can. So the first thing—
I'm being evicted from my
presentation. Yes. Right. No, we will definitely give you lots of time. So Alfonso, if you can advance to slide number,
Okay, there we go.
Yeah. So if the loan becomes due before the final plan payment, you can try and cram it down. So that means if the balance of the loan exceeds the value of the house, you can cram it down and say this creditor is only entitled to how much they'd get if the house were sold, which is the value of the house. You can look at the mortgage to see when the loan matured. Or look at the loan contract to see that. We get that reasonably often.
It's worth noting it's under the original payment schedule too.
Yes.
So in this day of loan modifications where loans are extended, you're looking at under the original payment terms.
Right. So let's go to number 19, the practical limit on cram down. If you cram it down because of the due date on the loan or because they took security interest, you have to pay off that balance during the plan. So not everyone's going to be able to afford to do this. So after you've identified this as an option, you have to decide whether it's an option your client can afford to avail themselves of.
And don't forget to factor in that if you're paying that off, you may need to also calculate that your client's going to be paying taxes and insurance directly. So factor that into their living expenses.
Okay, Alfonso, it's all yours.
All right.
I think our time is up.
Okay. My apologies. I don't know why my door is ringing. I'll be right back.
All right. Well, I'll talk instead, but I can't advance the slides.
I'm sorry. Zoom is being pretty glitchy today.
My apologies. Okay, where are we?
Just you and I only have a few more minutes to.
Okay.
If we don't want to cheat Eileen out of her topic.
Absolutely. So again, same thing with the junior mortgage. Most of the terms are the same thing with the first mortgage, same reasons. The reason you can, with the junior mortgage, sometimes we call it stripping off because it's wholly unsecured, which means that the house is so underwater on the first mortgage, that first mortgage is really just sort of floating up there, and it's not truly a secured mortgage, and that's why you're able to modify those rights, because in essence, you're not really modifying them. And that's what was said in the McDonald opinion in third circuit. As you can see in our examples, fair market value 100,000, the first mortgage 100, second mortgage can be wiped out completely or stripped off. You know, if there's at least a little bit of equity, and it doesn't take much, $1 of equity is enough, then you may not be able to. And that's why valuation can be really important. Well, if we have time, we'll go into that. So if we're not modifying the mortgage, typically we're doing what we discussed earlier, which is just a reinstatement or a cure plan. A payoff plan, sometimes even if you're not cramming it down, if the mortgage balance is a small enough balance, and I'm looking at things like $20,000, $30,000, it may be more economic to just pay it off in full. And sometimes you can save the client a significant amount of money by doing that. But again, you have to make sure that the monthly payments over a 5-year plan are going to be affordable. You can also try to use non-bankruptcy loan modification options and indicate that on your plan. And I throw this in as a rare occasion. Sometimes if your client maybe has something that happens right after bankruptcy, sometimes it happens, but there's equity in the property. Sometimes selling the house in the bankruptcy does make sense. Usually it's going to be more affordable for them to do it outside of a bankruptcy. But sometimes you can get benefit by reducing secured claims and allowing more money for your client. But that's sort of a rare case, but know that that's a tool. You can have a bankruptcy plan that sells the property. Real estate taxes, like any secured claim, can be paid in a Chapter 13 plan. Kathy, I'm going to ask you to chime in a little bit more because we really don't do a whole lot of this in Philadelphia because thanks in large part to my colleague, Monty Wilson, the city now has a very good owner-occupied payment arrangement plan. So we're almost always able to work something out like that for real estate taxes. So usually my real estate taxes might be if it's like a non-escrow mortgage and there's a couple of $1,000s. But you can pay them off with the interest rate at the statutory rate. And Kathy, it looks like you can break out, there's a non-interest bearing account and an interest bearing.
Yes, they're only entitled to interest on the face amount of the claim, the original unpaid balance of the bill, and then they are responsible to pay penalty interest that's accrued, and will continue to pay interest on the face amount through the plan. But you have to repay the non-interest bearing portion, but you don't pay additional interest. So most of the creditors around here file a claim breaking it down just for your convenience because everyone knows how it works. It's a very common thing around here.
Yeah, and to the extent that we have small claims, in Philadelphia, it's a similar thing. There's sort of a staggered tier thing and they sort of average out. Sometimes I question whether they're doing it right, but usually it's a small enough debt that I typically don't fight that for those ones. Now you can also, like any secured claim, if taxes are no different, you can cram them down to the value of the property as well. Redemption in Chapter 13 could be its own topic, so I'm just going to touch on that briefly. But at least for those of us in counties of the first class, you can, the municipal tax statute allows for redemption, meaning that even if you lose your house at a tax sale, and at least in Pittsburgh and Philadelphia, you can redeem it. Even outside of bankruptcy, if you had a lump sum money, you could tender that plus 10% and any reasonable expenses that the buyer had. In Chapter 13, you can do that, but you can stretch it out over time. And cram down, of course, is still an option available. And then I noted this when you did this slide, Kathy. You're right. You're never too old to learn. I had to look at that code provision. I'm like, I'll be damned.
Right. It happened to me. That I had crammed down, and then I luckily, I don't think the creditor knew this, but I found it out. And so now when I propose my language, I say, okay, it's going to be unsecured and non-priority when we're done with you.
Yeah. The few times I've seen real estate tax claims by the city, even though I think they would be entitled to priority, they've never done that. I think they just prefer to have the secured claim. So whenever you're going to do any kind of cram down, reducing something, the reason you're able to do that is because you're valuing the collateral. And that's what Section 506 of the code says. You're basically bifurcating the secured claim down to what the property is worth. So valuation is key. And the process that you value it in bankruptcy court, you can either file a motion. And Kathy, it sounds like your district defers to mostly doing adversary proceedings for that.
Yeah, they make us do that.
But under the regular code, and here you can actually put it in your plan as well.
Yeah.
So that's why knowing your own plan, your district's mandatory plan, and we all have mandatory plan forms and practices on that issue is worth knowing. But in any case, and it's worth knowing that claims of the governmental units have to be done by motion, even under the federal rule. And that's going to be like your HUD secondary mortgages, which are ones that oftentimes you can strip off. So when you're valuing property, there can be a number of sources. I look at the city value, I look at ePraisal, Zillow, and Trulia, and kind of get a feel. If I see a big variance, I might want to get an appraisal if it's going to make a difference. Sometimes it's so obvious, even if I find that the highest value, the first mortgage is so high, I know the creditor's not going to object, and I'll just use like an online value. But where it's close, an appraisal may be something I might want to look into it. Sometimes to help me decide, I will take a look at pictures of the property. I'll have my client take pictures because obviously condition of the property can really bring that down. Reverse mortgages. So, I know a lot of you are probably thinking evil. I know a lot of my colleagues do. I see there's a value in them. I mean, they are equity eaters, they have high costs, but sometimes they can be good things. But you have to be a 62 plus, there's no payment, you can have a stream of money, or you can pay off some debts. It's easy to default on them though, and that's the downfall for many of our clients. If you don't pay your taxes and insurance, unless you structure your loan so that they build those into an escrow, sometimes you can do that, you can be in default on taxes and insurance. And good news for bankruptcy is you can cure that default just like you can a regular mortgage, and you're just paying off what the mortgage company advanced for these taxes and insurance. But the question is, can the debtor afford to pay that? And that's often a tough time, because if they didn't have a mortgage payment, but they couldn't make their taxes and insurance, so they can be able to make the bankruptcy payments.
Okay, we're going to talk about avoiding a judicial lien. So I am going to go straight to slide number 34, example 1 of avoiding a judicial lien. So please, if you're not familiar with this process, go back and read the other slides. It explains different kinds of liens, but everybody knows that a judicial lien arises out of a court lawsuit. So we're not talking about taxes, we're not talking about the IRS, we're talking about, Best Buy sued you, someone sued you, got a lien. So there, in Pennsylvania law, a judgment is a lien against real property just automatically. They don't have to take any additional steps in the county in which that judgment's registered. So it's just sort of a bizarre analysis. So I wanted to put the numbers down on the page. It lined up when I looked at it. Sorry, it seemed to jump on this PowerPoint. But here's what you do. You add together the exemption that your debtor is entitled to, the liens against the property. So in this example, we've got an exemption, the real estate exemption of $25,150. We're adding to that the mortgage, which is a lien. Those add up to $40,150. That's more than the house is worth. So any judgment against that would impair your debtor's exemption. It would mean they wouldn't get the benefit of the exemption. That's the way to look at it. So in this example, you would get to avoid any judicial judgment that was against the house. And so just if this ever arises, and you think, oh, this stuff doesn't make sense, just go back to something like this, an example, and plug in your numbers and you will find the right answer. So let's look at example number 2. So this is a little different, same analysis. You are adding together the exemptions. And in this case, this example, we've got a joint bankruptcy filing, spouses filed, and I added their 2 exemptions together and the wild card, which you get to add to something else. And so here, the total of there's a mortgage against the house, add that to the exemption, that comes up to $92,950. And the house is worth a little more than that. So in this example, the debtor has some exposed equity. That's how the phrase people usually talk. They say that's exposed because the exemption doesn't cover it. So if you have a judgment lien of $5,000, you can't avoid it because it is less than the exposed equity. If you have a higher lien, you could avoid part of that higher lien, but not all of it. You could avoid it to the extent that it exceeds the value of the house. So again, sorry to run through this so quickly, but I think all you really need is to sort of go back here and plug in your own numbers. It can be a mind-bending experience trying to think of why does this make sense. I frankly gave up on that in bankruptcy a long time ago. I just take it for what it is and use it to my client's advantage.
I mean, the benefit is the section of the code 522F actually spells out the formula. So just plug in the formula and you'll see how the numbers work. Benefit is this can also be done in Chapter 7. Unlike strip-offs or what we were talking earlier, sometimes you can file a short Chapter 7 to discharge their other debts and eliminate judgment liens.
And the reason we are including it in this section is that you're improving your client's position and their sort of financial stake in their house by wiping this out. Then that isn't a claim against their house anymore. So Eileen, it is now, so Alfonso is going to stop sharing his screen. Eileen will pick it up and we will transfer to talking about all the things you can do to help a tenant in Chapter 13. Eileen, you're on mute.
Eileen, if on your screen at the toolbar at the top, if you click slideshow, and then from the beginning, it'll show just the slides.
But I don't think you want to go from the beginning because you're sort of halfway through. I think you can go to the current slide.
Yeah,
Slideshow. From current slide.
Yeah.
There you go. Sorry about that. And then you're still on mute, Eileen.
Yeah, I couldn't find the
there
unmute,
you
but okay. Do you see the slides on the left, or you just see the slide?
You can still see the slides on the left.
Yeah, you want to hit resume slideshow. There's a little gray box there.
Hello? Do you see the slides on the left as well as the main
We do,
slide?
yeah.
Let me see
If
I
you
can-
hit, there's a little pop-up box there that says resume slideshow. Hit
Well,
from
I'm on a
current,
separate.
yeah, from current slide, and
And
then
there-
resume slideshow. It's very little gray box
I
after you hit from current slide.
have current. I don't see.
Nope, you want to go over to the left from current slide. And if you click
Oh, I see.
that,
Okay, good. Okay, great. Well, I'll tell you what, you can see the other slides too.
This could work.
Before we go to that, I just wanted to mention, in case people didn't know this, when is the best time to file a bankruptcy if your client's in foreclosure? And at least for me, I don't know what the other two people would say, is if you know that that your client is going to be able to afford a bankruptcy and you don't have defenses to a foreclosure, then get it filed as soon as possible, because the longer you wait, the more expensive it's going to be to in the plan to catch up on that bankruptcy payments.
Right. I mean, in Allegheny County, we have a mortgage diversion program too, and that can put the foreclosure on hold for a good long time, but typically it doesn't really solve the problem. So we usually get involved at the initial stages, analyze it for Chapter 13, and if we can't do a 13, then we just say, call back when, when they don't give you a loan mod.
And then, but when's the last time you can file a bankruptcy to be able to use to save the house in a foreclosure is before the sheriff's sale. Once there's a sheriff's sale, it's too late. Unlike the tax redemption, sheriff's sales for taxes, where you can file it if you have a redemption period after the sale. I just wanted to mention that. So I'm an evangelist about using bankruptcy as well for eviction cases. And the benefits of bankruptcy are not always going to be to prevent an eviction, however, in all sorts of housing. So we'll go on to the types of housing that I think it's, hold on a minute. I have to move my view of everybody here. Okay. You can Chapter 13 bankruptcy is how, for us at least, most of the types of evictions that we deal with, we can use a Chapter 13 bankruptcy, but only if the lease has not expired. So if there is an expired lease, which is generally often our private leased tenants, Chapter 13 bankruptcy isn't going to help prevent the eviction ultimately, just like there's no real legal defense even in bankruptcy court, in common pleas court, if a tenant's lease has expired and the termination has been proper. There may be options to delay evictions with bankruptcy, but they're not going to be able, if it's an expired lease, to save a tenant from eviction. But Chapter 13 bankruptcy will help if there is, if the lease is not expired. And there are quite a number of types of housing that our tenants reside in that by law, those leases don't expire just because they don't just expire on their own accord. And those are listed here: public housing, site-based Section 8, all types of other types of subsidized housing, low-income housing, tax credit housing, even if your tenant doesn't have a Section 8 supplement to that. I don't know if there are any jurisdictions in Pennsylvania. If so, it's probably only Philadelphia might have rent control housing. Manufactured homes, tenants who live in manufactured homes by statute cannot be, their leases cannot be terminated. Their leases for the rental cannot be terminated unless there's a breach of the lease, and that is the same for all of these types of properties. So these are the types of housing which, if a tenant is being faced with eviction, a bankruptcy, and if not always, but primarily if the reason is for, but it's not exclusively always, if the reason is for non-payment of rent, then a Chapter 13 bankruptcy can be used to force a landlord, just like it forces a mortgage lender, forces a landlord to accept payment plan that would cure any default in the rent over time. Now, which would mean if your tenant can afford to pay the current rent plus extra every month, so that within at least 3 years, but possibly up to 5 years, then the tenant can use the bankruptcy to prevent that eviction. The assumption issue is in the Chapter 13 bankruptcy, a tenant is allowed to assume a lease in in Chapter 7 bankruptcies, tenants don't have that, the debtors don't have that opportunity. And so that is one of the reasons why Chapter 7 isn't necessarily going to be able to be used most often to prevent evictions. And Chapter 7, of course, would result in the total discharge of all the rent debt to a landlord. We'll talk about when that option might be available, but in most cases, it's not going to be available. So we'll go on. So in Pennsylvania, we'll go to the next one. So in Pennsylvania, the question about when can a bankruptcy be filed, which would then result in the automatic stay, which is, I mentioned at the beginning, is the most powerful tool. It will stop an eviction. It'll stop a foreclosure sale. But it became so successfully used by tenant legal services lawyers, and especially in Philadelphia, as a way of stopping evictions for our clients. If a bankruptcy had been filed before the constable actually changed the locks, that the law changed several years ago, and that's not permitted anymore. So in order to file a bankruptcy to stop an eviction action, when it's possible to use either a Chapter 7 or a Chapter 13, what's critical is knowing that the bankruptcy stay will not be effective automatically if there actually is a judgment for possession issued in the case. A judgment if there's a final and judgment for possession, then there's a separate rule which comes into play about whether a tenant can use the bankruptcy stay to stop an eviction. And this applies whether or not it's a Chapter 7 or a Chapter 13 bankruptcy. So it's critical for our tenants, if we're thinking that they owe a lot of money, how are they going to be able to pay it back? If we're going to use a bankruptcy, that the bankruptcy has to be filed before there's a judgment for possession, or else what the law requires is that what the law allows then is, if there is a judgment for possession already issued, then the only automatic stay a tenant gets is for 30 days, but only if the tenant, at the time that they file the bankruptcy, Chapter 13 or Chapter 7, delivers to the bankruptcy court clerk a payment made, a certified check or a money order made out to the landlord, but it has to be delivered to the bankruptcy court in the amount of 1 month's rent. And then if that occurs, a bankruptcy is filed even after there's a judgment. That will stop the eviction for those 30 days. The bankruptcy stay will continue only if after those 30 days or before those 30 days ends, if only within those 30 days, the debtor pays to the landlord all the rest of the money that's owed. And if the debtor cannot pay all the rest of the money that's owed when they file a bankruptcy after a judgment entered against them in an eviction action, then there is no more automatic stay. The stay cannot be extended, and in fact, the clerk will then notify the landlord and the debtor and the parties that the stay has been lifted and the eviction can proceed. So that's why, because of the complicated issues of supersedious and how it intertwines with this bankruptcy law, we still have some wiggle room. Oops, oh dear. Landlord tenant, okay. So we'll go on to the forms that have, and if you do file if your tenant does file a bankruptcy after a judgment is entered, then there are two special forms which have to be signed by the debtor if there is a judgment for past due rent, which then, as we know from landlord-tenant law, means that that debt is curable under state law if it's paid before the constable actually throws the tenant out. So the first form, which has to be filed if there is a judgment against the tenant when the bankruptcy is filed, and that's the time when the tenant has to pay the month's rent to the clerk, the bankruptcy clerk, is this Form 101A. Let's see if I can, your screen sharing is paused. Let me see if I can pick this up.
It says your screen sharing is paused.
Yeah, it says my screen sharing is paused. I don't know why, but let's see. And I've lost my. Okay, resume share. I found that. Okay. Well, okay. So I'm not going to be able to. I'm not going to spend the time trying to figure out why I can't get this now. But I'll. So Form 101A, however, is a form that says that the tenant has to sign, the debtor has to sign, saying you rent your residence, the landlord has obtained a judgment against you. You have to fill in the landlord's name and contact information, and you have to, and the tenant has to certify that under state law, the judgment for possession still allows the right to cure by paying all the rent, which it would in Pennsylvania. And that you have given, the tenant has given the bankruptcy clerk the month's rent. So that's Form 101A. And then if the tenant is going to be able to pay the rest of the rent, which then, in my opinion, means that there's no need for the bankruptcy after that point, the tenant would then have to file 101B, which says, I have paid the rest of the judgment amount to the landlord. And if the tenant certifies that, then the stay will continue just as it would under state law as well. So the timing is essential. If there, let's see, yeah, we're going to go through all the different types of. Get back to here. If the landlord has sued for eviction and the case has not yet been litigated, there is no judgment, and the tenant can file the Chapter 7 or Chapter 13 bankruptcy without even having to file these forms and without having to pay any money to the bankruptcy clerk. There's no judgment, and therefore they get the benefit of the automatic stay just by the filing of the bankruptcy. So there's no problem there. And that would be the ideal time to file a bankruptcy if you're going to use it to help prevent the eviction. If there has been a judgment for, If there has been a judgment for money, but not for possession, then there is no judgment for possession. And even though the debtor is told they owe the money, again, the bankruptcy can be filed without having to pay any money to the clerk and without having to submit any form, and the automatic stay continues until the bankruptcy is processed. If the judgment has been entered by the magistrate and then the debtor files an appeal within the 10 days allowed by state law, then there is no judgment anymore. That judgment is wiped out, the appeal is de novo, and the bankruptcy, and then again, the tenant doesn't have to pay 1 month's rent to the court, and the bankruptcy, they don't have to fill out the forms, and the bankruptcy stay continues indefinitely until the bankruptcy is processed normally. So if you have a tenant that you think you're going to be, who comes to you, and even if there's no defense to that magisterial district court judgment, but you want to file the bankruptcy to stop the eviction, you need to file the appeal first in order to obtain the benefit of the automatic stay. So file the appeal in state court and then get that bankruptcy filed. Let's say you've gone to, if you've gone through an arbitration hearing and there's an arbitration award for judgment for possession. There's 30 days to file an appeal to the Court of Common Pleas. So an award is not a judgment. And because an award is not a judgment, then again, your tenant, if you were to file the bankruptcy before the 30 days is up, that you have to appeal, then you can do that and get the benefit of the bankruptcy stay. If you've appealed to the Court of Common Pleas after the arbitration award and you've had the trial, a judge only issues a verdict. A judge or a jury does not issue judgments. And so even if you've had the trial and your debtor has lost and you have that verdict, because there is no judgment, you're still protected by bankruptcy law to get the benefit of that automatic stay.
And it's worth noting that using that appeal process can also work with liens. Just since you're talking about appeals, that you can benefit just by appealing them, and save yourself the lien avoidance issue.
Oh, okay, that's good. And finally, if you have a tenant who has been going through the appeal process, and your case is pending, and your client, which I know hardly ever happens, stops paying the supersedious, and as a result, the supersedious has been terminated. If you file your bankruptcy before the constable actually evicts the tenant, then again, the termination of a supersedious does not affect the status in the Court of Common Pleas of whether there is a judgment or not. And the only issue for the bankruptcy court is whether there's a judgment. And even if the supersedious is terminated, then you can file that bankruptcy without having to pay the 30 months rent and without having to worry about the bankruptcy stay being vacated automatically after 30 days. So as long as the tenant is in possession and the case is on appeal, that appeal is still exists, even if the supersedious is terminated, and therefore there's no judgment. So there is one option though, which has not been litigated as far as I know. I did start to litigate it, but we ended up settling the case, was if a landlord has obtained a money judgment and a judgment for possession. The debtor doesn't file an appeal within 10 days, but they file an appeal from the money judgment. So there is a judgment for possession. You're kind of stuck with that judgment possession rule. But let's say you believe that because of habitability or because you have proof that they've actually received most of the money, that all they owe is that the landlord only is owed $100. And the tenant therefore then pays the full amount that they believe they owe because there is no judgment for money yet. The bankruptcy court automatic stay rule says you have to pay the amount on the judgment required to satisfy that judgment. But because you filed your judgment, your appeal from the money, there is no judgment because that's a de novo appeal. The question is, can you avail yourself of the ongoing automatic stay because you're asserting to the court that you have paid what is owed, which is what the purpose of that rule about paying the judgment amount is when there is no judgment. I do think that there could be a good argument that the automatic stay should continue in those days, in those situations. What happens if you file an appeal I'm sorry, what happens if you file the bankruptcy 5 days after a magisterial district court judgment, but without first filing the de novo appeal, where there are 2 cases which have held that the judgment, the term judgment for this purpose in bankruptcy court means final and unappealable. So because that is also not a judgment anymore because you filed it before the appeal period ended. So if you filed the bankruptcy before the appeal period ended, the appeal period, the judgment for possession was still appealable, and therefore, again, you don't have to file those 2 forms or be concerned about the expiration of the automatic stay. Sometimes there are cases where your client has breached the lease in other ways as well. And in this was the Vanguard case about this issue that for Chapter 13 bankruptcies, when there's an unexpired lease, of course, you can use bankruptcy to cure non-monetary breaches as well as monetary breaches. So in this particular case, there was a small assault, a conviction for a rather small and sympathetic debtor, I suppose, and the bankruptcy court held that despite the fact that might have that conduct of carrying a pocket knife and lighting cigarettes in the lobby and being nasty to the guard, that those were breaches of the lease that might have resulted in eviction. The bankruptcy court held you could use a Chapter 13 bankruptcy, and in your plan you would put where it allows for other conditions of the plan, you'd say debtor promises to behave from now on. We've done non-monetary breaches in our office that have worked, but we've never done it unless the debtor has also owed money to somebody somewhere. I don't know what a bankruptcy court would do if there was no money owed to anybody and you just say we need to do a non-monetary breach bankruptcy case. So, okay. So, and then these are different examples and as you can see, most of these examples are from Pennsylvania. Bankruptcy is not used a lot around the country by legal services lawyers, and it's used even fewer in eviction cases. And like I said, I evangelize about using bankruptcy to help tenants when you have nothing else to way to stop that eviction. But anyway, and I was just doing some updating research, and these cases are quite old. We've done it we once had a tenant who was in a wheelchair and decided every time he's elderly, he got angry at somebody, he would ram the wheelchair into that person he was angry at. And we were able to use the bankruptcy where he promised he would stop doing it, and we got help for him, social services help. So these are slides of different cases where bankruptcy is used for non-monetary breaches to stop an eviction. So since there's a lot of them, that's good. So I can go on to the next topic then. There is the potential of using a Chapter 7 bankruptcy to discharge the debt and allow a tenant to remain in public housing. It only would work for public housing and possibly for site-based subsidized housing, and probably not that latter type of housing if it's going to work at all. But that's because there is a special code section, this particular code section, which prohibits governmental units from adversely affecting the benefits that any debtor receives from that governmental unit, just because there's a debt that was owed or just because the bankruptcy has been filed. It says no governmental unit may do any of those things: deny, revoke, suspend, refuse to renew, other similar grants, or to condition it based upon solely because the debtor has been a debtor or has not paid a debt. So the argument has been made that public housing is a government benefit and public housing is a governmental unit. And therefore, if a tenant were to file a Chapter 7 bankruptcy, then by virtue of this particular code section, the government cannot terminate the tenant's right to continue to live in that property, even though they've wiped out all that past due debt. There is only one Court of Appeals case that has ever dealt with this issue, and that is this case from 2002. And the people, therefore, in the Second Circuit, the tenants there can use Chapter 7 bankruptcies all the time for public housing tenants to wipe out past debt and allow the tenant to remain. There are not a lot of cases about this issue because not a lot of legal services lawyers use bankruptcy in the circumstances I'm urging you all to use it for. But we have tried it in our area twice where it's been litigated. And the first case, we actually won on we lost with the bankruptcy court, but we won with the district court. But then the landlord appealed it to the Third Circuit, and these were Chapter 7 bankruptcies. But the Third Circuit, by then the case had been closed, so the Third Circuit punted and just said the whole case is moot. So that was not this case that you see here. The second case we filed, the bankruptcy court ruled favorably for us, but it was reversed by the district court. We decided not to file an appeal because we didn't want to screw it up for other people at that time. I don't know if anybody can tell me, maybe Armando, maybe you can tell me. My understanding is that in Philadelphia, litigators have been using Chapter 7 bankruptcy for public housing tenants, and they're allowed to do that. Is that still and that's been the case?
Typically, where it's come up that I'm aware of has been for utility issues, where I think falling behind the utility violates a PHA lease, and we've done those. I do know that this was litigated by the Consumer Bankruptcy Appeals Project. I think it got settled out before it went anywhere. In terms of using it like you're proposing, I'm not aware of it. Certainly, when I was in private practice, it just didn't come up.
Yeah, right. When you wouldn't, because we're the only ones who represent public housing tenants. But it's an issue that's ripe, and I know that some of the people who are listening today, I have tried it, and I've given my little spiel in the past, and I think more than what I've been hearing is that things normally get settled. So you might want to try using a Chapter 7 for a public housing tenant, because there's the cost benefit analysis from the landlord side as well, that they don't want to, they don't necessarily know the law, they don't necessarily practice bankruptcy, and you might get settlements. Similarly, the argument it can also be argued that these site-based subsidized housing facilities are, because they're so intertwined with the government, because they're so regulated by the government, as this Michigan case held, it is tantamount to a government unit, and therefore for this Michigan case, Chapter 7 bankruptcy was permitted to wipe out that debt. And New York did it for a different type of housing, city-owned housing. But I was just looking, Pennsylvania did not agree with Michigan. These cases were before Osentowitz, but I just saw this case that was issued earlier today, this year, from New York, which held that that type of housing is not a government unit, and so would not apply. But it's also some kind of worth pursuing. So I think I made it through. Let's see. What do you say here? Relief from
I think that takes us to sort of the last quick thing. Relief from stay, or as I like to say, stuff happens. It is not uncommon that a debtor who is particularly in the mortgage issue, who's filed behind on the mortgage pre-bankruptcy, may fall behind post-bankruptcy. And it typically arises by, when they fall behind. Here in the Eastern District, the debtors make their direct mortgage payments directly to the mortgage company. In the Western District, everything goes through the trustee. So typically, for slight difference, is just who brings the motion. If my client falls behind on their mortgage payments, the mortgage company is going to file a motion for relief from the automatic stay. And typically, most lenders or servicers are going to allow you to work something out at least one time. Typically, we resolve it with a stipulation where either those post-bankruptcies are going to be folded into the plan. Perhaps I can, it's easiest if I have some months left, like I only have the client in a 36-month plan, maybe I can just extend out the payments. Or less commonly, the client will make larger mortgage payments to the mortgage company at a time for a period of time. Usually they're only offering 6 months, so that might be a harder one to do. With bankruptcy payments to the trustee, our trustee sort of has a rule of thumb of like 2 payments before he files a motion to dismiss, and he's very lenient about giving extensions. So typically we can, either catch up on that either by modifying the plan to cure the arrears, or the client can catch up, and the trustees usually will withdraw the motion. Trustee certificate of default isn't something we have. I suspect I know what it is, but Kathy?
Oh, I thought this was a universal pleasure. Yeah, our trustee will file what they call a COD and asking for the case to be dismissed. And then what happens is the court issues a scheduling order giving you lots of time. I mean, usually, then they'll say, well, if you haven't done something in 2 months, we're gonna, and they schedule a conciliation date when they issue that order, on the assumption that you are probably going to file an amended plan or file an affidavit saying, oh, we fell behind, but so we'll file an amended plan later. So it's just sort of their way of moving the case along.
That's what I thought. Our trustee just withdraws a motion or files a new motion because it's a relatively quick motion for them to do. With mortgage servicers, if we negotiate something for post-petition arrears, they will often include a requirement that they have the option of doing a certificate of default. So if the client falls behind again, they don't have to file a new stay relief motion. They just have to give us 10 days notice. If the client doesn't cure, then they can file a certificate of default. Our judges will typically hold those for 7 days though. So even if one's filed and I think my client can catch up, I'll file like an objection to the default. But that's sort of how we do it in the Eastern District.
Yeah, we have that, and everyone calls those drop dead orders.
Yeah.
But yeah, you don't drop dead immediately. So I think we are actually finishing this on time. I'm very proud of all of us. So the last thing we wanted to talk about was just resources. There's a lot out there. People who do bankruptcy tend to like it. And so we're happy to all take questions and help people with this. I think that the National Consumer Law Center manuals are like the single most useful publications on the face of the earth. So I would say all legal services programs hopefully have access to them. You can get them online. Amy Carpenter says we need the second poll.
Yeah. People are chatting like crazy saying, did I miss it? Did I miss it? I'm about to launch it now. Nobody has missed it.
Thank you for keeping everybody here.
Sure. We also have a question I saw while we wait, if you want to take that. Will a Superior Court appeal stay an order for possession?
This would be in a landlord or an eviction?
It doesn't say.
If the Superior Court says no eviction isn't allowed, then of course it would. If you're talking about will just filing an appeal stay an eviction, no, it won't automatically. There are lots of rules in the appellate rules of procedure about that.
And he responded, he was talking about eviction. I don't see any other questions that have come in.
I had a couple questions. One was about given that there is a difference between somebody who signs the mortgage and not a note or a note. And I've learned that the mortgage servicers will not allow folks who have signed the mortgage but not the note to obtain loan modifications. I'm wondering if debtors who only have signed the mortgage are still allowed to file bankruptcy.
Absolutely, because they own the property. As long as they have a property interest, it's a debt that's attached to their property. They can cure the mortgage or do all the other things that a property owner could do.
So that would
the
be
language in the code is pretty broad. It just says if you have an interest in it.
Yeah. Even if it's an heir who hasn't probated the estate yet, they could still do a 13.
a possessory interest even.
Yeah.
Although you may run into problems claiming an exemption. So I had that come up recently. Spouses and the house was owned only by the husband, and we got into a fight about whether the wife could use her an exemption in that. And so rather than fight that to the end, I was able to get a different valuation for the property and avoid the problem.
That's the best way to do it.
Kelly, are we finished?
If you don't have anything more, yeah, we're done.
Yeah. I just want to clarify what Kathy said. I'm always happy to answer questions. So I think my email is somewhere in the materials or something. I love talking shop. So please feel free to send me an email or give me a call to talk about issues.
Also, if you're trying to find Alfonso's or anyone's contact information in the conference app, just go to this session name that he presented, and you'll find his bio and an email address. Same with the other presenters.
Okay, good. Thanks for listening, everybody.
Sure. Eileen, did you have something?
Sometimes I get worried when there aren't questions. So all I can say is if you have a lot, if you kind of like your head is swimming, then please go to Bankruptcy 101 that we'll be doing too.
Next Tuesday.
Okay. Great. Thanks for being with us, presenters, and sharing your knowledge with us. And thanks for everyone who attended. Everybody take care.
Thank you.
Bye.